During a break at trial, the defense attorney comes to me and makes me a settlement offer, and it's a substantial settlement offer. Can I sit around and wait a few hours till we take more testimony before relaying that settlement offer to my client? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So here's the scenario. We're at trial. It could be an accident trial, or maybe a medical malpractice trial, or even a wrongful death trial. And now, during the course of a bathroom break, the defense attorney comes over to me and says, listen, we'd like to try and settle this case. He makes me a very substantial offer. Let's say he offers $1 million. And now, I promise to tell my client about it, which I have a legal and ethical obligation to do. I have to advise my client about the settlement offer. Why? Because I can't make the decision to settle this case on my own. I don't have the authority. The only one who has the authority is my client, the injured patient, the injured victim. So now I have an obligation to talk to my client about the offer. We have an obligation to discuss the risks, the benefits, the alternatives to this particular offer. Now, if I want to sit and wait and hear what kind of testimony comes in during the rest of the afternoon before discussing that settlement offer with my client, is that appropriate? I would argue, no, it's not appropriate. You want to know why not? Because my client has to have the benefit of knowing that information to make an educated decision about whether or not to proceed forward with trial. Because as testimony continues, other information may come out from different witnesses that may sway the entire case. And now, by the end of that testimony, at the end of the day, the defense may feel empowered, like they're winning the case, and the defense may turn around and say, hey, remember that offer I made you this morning? That's off the table. Forget about it. We're now on top of the world. We're winning this case. You have a nice day. That's entirely possible. So I would argue that I, as the attorney representing the injured victim, have an absolute obligation to talk to my client as soon as possible after the offer comes in. Now, when we get back into the courtroom, I can always ask the judge for a few minutes to talk to my client privately to discuss the settlement offer that's come in. And in all likelihood, the judge will allow me at some additional time to talk to my client. When a defense attorney makes a settlement offer during the course of trial, it is my obligation to notify my client about that offer in order for him to make an educated decision as soon as possible about what he would like to do. So why do I share this quick information with you? I share it with you because this comes up during the course of trial from time to time. And it's important for you to understand as you're considering whether or not to bring a lawsuit for your own particular problem. You know, I recognize that you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're still thinking about bringing a lawsuit, but you need your questions answered first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.